Hello and good morning. Um, so let me try that again. Let me open this too. Right. All right. Good morning, class. How are we doing today? Um, so this is kind of to just recap and explore some of the other actions that Jefferson and the Democratic Republican Congress took against the Supreme Court and the courts in general following the case of Marbury versus Madison and the repeal of the Midnight Judges Act. So, um, first, two things. One, I've come outside to escape my children. They may come outside at any time, so I apologize for any distractions, but they'll be cute distractions. So, hopefully, it's not too bad. Secondly, um, I want to start this conversation just by pointing out that the powers of the court are directly related to the court's influence, or the court's reputation, right? If you guys remember in Federalist 78, the excerpt on page 191 of AMSCO starts off by saying, the judiciary will always be the least dangerous to the political rights of the Constitution because it will be least in a capacity to annoy or injure them meaning the political rights found in the Constitution. Since it has no influence either over the sword or the purse, right? And we see that play out in the in this saga here between Adams or the Federalists and the Democratic Republicans. So, um, and this especially plays into the reason why Marshall makes the decision that he does, because he realizes the weakness of the court, and he realizes um, that if he doesn't make a decision that the people will accept, um, then Jefferson could just ignore the decision, right? So the reason why they're able to repeal the Midnight Judges Act and get rid of all these Federalist judges is because, I mean, there are no political consequences. As a matter of fact, if they hadn't done anything about it, there may have been political consequences because, as you guys should have seen in the readings, there were people who were actually writing petitions to their congressmen to do something about these midnight judges that were appointed. Everybody kind of saw this as a way for the Federalists to undermine democracy. So in that case, the legitimacy of the courts were compromised, and that opened the door for Congress and the president to attack the courts openly, and everybody approved of it. But in Marbury versus Madison, there was no recourse for Jefferson to attack the courts. I mean, let's think about it. I mean, not only did Jefferson win the case, but what is Jefferson going to do in that case? I mean, he has to at this point acknowledge the legitimacy of Marshall's decision because there's literally nothing he could do about it. Jefferson, or rather, what is he going to do? Is he going to give Marbury the post? I mean, that's not going to take away the power of judicial review from the courts. Is he going to? I mean, he could make a statement saying we don't acknowledge judicial review or something like that. But I mean, really, that's not going to do anything about it. So I mean, it's really a brilliant move by Marshall. But the point here is that the case was, I mean, Marshall. I mean, and you got to think of it in the context of the time as well. The average person isn't going to be able to make the distinction, the judicial review distinction, that they just suddenly gained this power. All they're going to see is, oh, well, the Supreme Court sided with their political opponents. That is, and that's something that's probably going to be respected. So there are a few other things that happen. I didn't, of course, I think the document and the work in it was long enough, but there are just a few other points that I wanted to get to. Um, First of all, Congress did not end with the repeal of the 1801 Judiciary Act. The act itself, I mean, once they repealed it, they realized, well, some of the changes that they made in the 1801 Act were important. Like, for example, um, the Supreme Court justices writing circuit. It was an immense burden on the judges. I mean, basically, writing circuit means that they actually had to, if their circuit had 3 states in it, for example, that means that while they, half the year they'd be serving on the Supreme Court, and the other half of the year they would be writing circuit, going from one court in their circuit to another, hearing cases from different, from different states. So it was an immense burden on them. So that's something that they sought to address in the new Congress did. But I'm kind of digressing now. The whole point of me bringing this up is that part of the repeal, what the repeal did was it reversed the 1801 Act, and it defaulted back to the 1789 Act. And if you recall, one of the things that the 1801 Judiciary Act did was it removed one of the Supreme Court justices, so there couldn't be ties anymore. So it reduced the number to 5. But if you go back, once you repeal it and you replace it with the original Judiciary Act of 1789, then all of a sudden there are 6 justices again, right? And who gets to appoint that justice? Well, Jefferson does, right? So Jefferson gains he's able to appoint somebody new to the Supreme Court because of that repeal. And when he creates the 1802 Act, he keeps the 6 judges because he continues the justices writing circuits, but he just decreases the amount of circuit writing that they have to do. So basically, they only have to go to 1 circuit rather than 3. Right. So the second thing that happens is there are actually 2 cases where in this time period under Jefferson where Supreme Court justices are impeached. Now there are 2 that are impeached. Only one of them gets removed. And the first one, the Supreme Court justice was, he was an alcoholic, and he was openly political, more so than any of the other justices. So now you could argue, is being an alcoholic grounds to remove somebody from office, right? Does that satisfy the good behavior by a good behavior violation? You could say it does or it doesn't. But it was clear that these were in part politically motivated, right? The second impeachment, largely, he was impeached but not removed. Chase was his last name. And in large part, the reason why he wasn't impeached was simply because Thomas Jefferson realized that he was setting a precedent of impeachment to remove judges that wouldn't rule favorably with the Congress, and he realized that there was a problem with that. So he kind of backed off. But this is another check that Congress has on the Supreme Court. I mean, they can impeach the members of the Supreme Court if they're openly political. And remember, the legitimacy of the court is the thing that will determine whether or not what Congress is doing is acceptable to the public. If Congress just starts removing justices because they want to do whatever they want, like they don't want the justices to get in their way, then the public might not respond well to that and might start voting those people out of office, right? Same thing for the president. The president is an elected position as well. So if the president is openly attacking the Supreme Court, then that could, in a way that the public sees as unjust, that could threaten the president's future in politics. So these are really the only points that I wanted to get to. If you guys have any questions, feel free to shoot me an email. Of course, you should know it by now. It's ctunez, CTUNEZ at dateschools.net. And I will gladly answer them like I always do. All right, we got a few more videos forthcoming, and these videos are designed um, to save you time, not waste your time. So if they're not accomplishing that, there's going to be, um, a few supplementary texts that I send to you guys. I say supplementary; they are required, but they are, it's going to be much less questions than the previous one. But we're going to explore some other instances in history, very briefly, where the Supreme Court was challenged, and in some cases it was challenged successfully, and in some cases it wasn't.